three very important rules. It would change three rules that have been in effect ever since federal laws have regulated the union arena. First of all, it would authorize what are called intermittent or short duration strikes. That would mean that a group of employees who wanted to put pressure on the employer, or a union that wanted to put pressure on the employer, don't have to actually go out on strike and stay out on strike. They can simply stop work in the middle of the day and then start up again, disrupting operations, called an intermittent strike. Also, they can do wildcat strikes, which means strikes that are called without the union's approval. And so the damage done by those strikes, the union has no responsibility for, but the employees can still do it, and the union can induce them to do it if they want to. So short-term intermittent strikes, strikes for part of a day or a day to disrupt operations would be permitted. Current law also forbids what's called secondary boycotts, where a union that has a dispute with one employer takes that dispute to uninvolved third parties. Say, for example, the union is trying to organize Coca-Cola or another food products company, and they want to put pressure on that company so they could picket the grocery stores and the warehouses that house those products in an attempt to further disrupt the company's operations. That's illegal under current law. But under the PRO Act, secondary boycotts, where the union can use third parties not involved in the dispute, not involved in the collective bargaining, to put pressure on the employer, would be authorized. This puts a powerful weapon in the hands of the union. Finally, the PRO Act would not allow employers to replace economic strikers. Under current law, if employees go out on strike, the employer can continue to operate its facilities using its supervisors, who of course are not part of the bargaining unit, and also any other employees that it wishes to hire to keep operating during a strike. In addition to that, if the company decides, it can replace economic strikers. None of that would be permitted under the PRO Act. A company would shut down during a strike and essentially have no options to continue operating. Again, this tips the balance strongly in favor of the union in such situations. Candidate Biden, when he was running for election, openly declared that he wanted to hold the executives of corporations personally responsible for any breaches of employment and labor laws. When it comes to labor laws, he wanted to make sure that companies were punished, not just corrected, for violations of the labor laws. So under the PRO Act, the current law where if a company violates the law, the workers are put back in the same position they would have been in had the violation not occurred. For example, they could regain their jobs, they can get back pay, and so on. They're basically put back in the same situation. Under the PRO Act, additional damages would be piled on in order to further deter the company from supposedly violating the law. For example, there would be fines that would be imposed, not just remedies, but actual fines would be imposed on the company. In addition to that, the remedies would now include not just making the workers whole, but also providing compensatory and punitive damages to them. The PRO Act also would provide, and President Biden has openly declared that he wants this and would do it without the PRO Act. It would provide that executives of corporations that are held to have violated the labor laws would be personally responsible for the damages. Not only that, but President Biden openly declared that he wanted, in some cases, those executives to be held criminally liable if they intentionally cause those violations. So that's a dramatic increase in the penalties and the risks for opposing unions in the new environment if the PRO Act is passed. One final thing, and that is under current labor law, if labor law violations are tried by the National Labor Relations Board, and that's where the penalties and remedies are assessed. Under the PRO Act, the individuals involved or the union have the right to file a companion federal case to recover damages in federal court against the company. So the company has to fight on two fronts. The NLRB then goes ahead and adjudicates the liability issue, but then damages go to federal court where the company faces yet another trial on damages. This is a very interesting question. First of all, remember that this legislation is a central part of the legislative and administrative agenda for President Biden's administration and for the Democrats who have congressional majorities. So this is something that is very central to their purposes, and they're not going to give up easily. The PRO Act was originally passed as a separate piece of legislation in 2019, and then again was passed as a separate piece of legislation in the House of Representatives earlier this year after the inauguration. So it's already passed the House of Representatives twice. The last time it passed the House of Representatives, there were a few Republican senators who voted for it as a crossover. Currently, the act is under consideration in the Senate as a separate piece of legislation, but it's also now, in the last week or so, reappeared as a part of President Biden's infrastructure legislation plan. It's included in that. And as you know, that's a major push in Congress to get the infrastructure legislation passed. And it's very possible the PRO Act could simply sail through as an adjunct to that piece of legislation. Whether or not it does, the support for the PRO Act has been growing within the Senate. Last month, there were 44 senators out of 50 Democratic senators that were actually co-sponsors of the PRO Act. This month, the number is up to 47. Last week, there was a meeting with the Democratic Party and the unions. At that meeting, one of the things reported in the news, at least as far as the news is reporting it, is that the unions involved gave notice to the Democratic Party that they will no longer support even Democratic candidates for Congress who do not vote in favor of the PRO Act, and that they would cut support for the Democratic Party as a whole if the PRO Act were not passed soon. So you can see the pressure that's building to get this piece of legislation across. Currently, by most nose counts, there's not enough to pass it as a standalone piece of legislation. That could change in many ways. Chuck Schumer could move the co-sponsors of the act from 47 to 50, at which point he would bring the act to the floor, having 51 votes. All that would need to happen is they do the nuclear option, and at that point, eliminate the filibuster and the filibuster rule, and vote the act in with 51 votes. That's also a possible pathway for the administration's infrastructure bill, which includes the PRO Act. So although the Democrats have not yet passed the act in both houses, the game is getting narrower and narrower, and the pressure is building. So it's not unlikely that the PRO Act could pass in the reasonable near future.